Good morning. My name is Cullen Sweeney. I'm the Chief Public Defender for Cuyahoga County. I've been a lawyer since about 2003, doing primarily appellate and post-conviction work for the Public Defender's Office before now becoming its Chief Public Defender. And our office, I should say, has about 134 employees. We work in multiple courts. We work in common pleas court handling felonies, in Cleveland Municipal Court handling misdemeanors, in juvenile court handling both juvenile delinquency cases involving minors and then parental rights cases involving the parents. And then we also handle appellate and post-conviction cases.
That's great. And I guess maybe the first question I just thought of to ask you is, when would somebody need a public defender? At what point do you guys step in?
Well, I think that there's a real gap there in a way. When somebody might need a public defender and when they would get one is a little bit different. I think they need one anytime there's a risk of being charged with a criminal offense. As a practical reality, though, you won't really get your permanent attorney assigned until the charges have been filed. And if it's a felony case, you've been arraigned, indicted, and then arraigned. So sometimes that happens well after the alleged criminal conduct. So
yeah, so that kind of leads us into the next question I have, which is that you presented this race and justice system PowerPoint that I have. So there are some statistics which we'll get into in a minute, but one of your slides is law versus reality. And the thing that I'm most interested in, I think for the purposes of our conversation, is what a law says: no state shall deny any person within its jurisdiction the equal protection of the laws. But that's not always the reality, is it?
Yeah, I mean, we aspire as a sort of society and our legal structures to be colorblind, in the sense that outcomes and treatment of individuals should not depend in any way upon their race. As a practical matter, because, and as we could talk about, so many of the decisions that are made are discretionary, in the sense that the actor has a choice whether to do one thing or the other. Individual and implicit bias, and sometimes explicit bias and prejudice, plays out. And so one of the challenges is how do we confront that and realize what our aspirational goals are, so that everybody receives the same outcome. And sometimes it's differences based on race, sometimes it's differences based on income, and sometimes there's an intersection between the two. But I think there is no question, I know we're going to talk about this later, that Black and brown people are stopped more frequently, arrested more often, and receive worse outcomes in the criminal justice system. And the question is, what can we do to make that better?
Right, and one of the things that I think leads to that kind of over representation within the justice whole system is some of the realities you kind of laid out here. Like, could you explain maybe what a pretextual stop, even though it's constitutionally valid, what does that mean, and how does it work? So
under the Constitution, we have protections against unreasonable searches and seizures. So in other words, in general, the police cannot just stop and detain you, cannot go through your things, cannot ask you questions. But in the traffic context, without having probable cause or at least reasonable suspicion that a crime was committed. But in the traffic stop context, what often happens, and these are what's referred to as a pretextual stop, an officer might pull you over for failing to put your blinker on. Whereas, that's that is a traffic offense, and maybe the officer lets it go, maybe the officer doesn't. But if the officer has a gut feeling that perhaps this car may have drugs in it, may have a gun in it, they will use that legitimate traffic stop, which they may not have otherwise made, in order to then stop the car, engage the individual, and eventually potentially search the car. And so there's been challenges to whether or not that practice is constitutional. And the Supreme Court, in a case called Wren, upheld that as constitutional. So what it means is it gives a lot of discretion to an officer. Someone's driving through a community. Does the officer pull that person over for a de minimis traffic violation or minor traffic violation? Sometimes that does, it plays out that becomes have a greater impact on Black individuals who are more likely to be stopped for these minor traffic violations.
Yeah, and it seems too that one of the reasons for that is that communities of color seem to be over-policed. So therefore it creates a high crime corridor in that.
Sure, I think there's a couple of things that are going on. In some parts of the community, the police have a more active presence, and it's complicated because I think some aspects of the community want the police there. I mean, it is true that in various parts of the city, there's higher violent crime rates, and so you want more of a police presence. But it does mean that on a daily basis, there's more interactions with law enforcement. And then additionally, in some of the other areas of Cuyahoga County or in suburban areas, because of the pretextual stops, even though those communities may not be over-policed, in general, the individuals that end up getting stopped are more likely to be minorities than white individuals.
Yeah, here in Cleveland Heights, we had a report come out a couple months ago about the number of traffic stops, and the majority of them were people of color, Black mainly. And one of the things that the criticisms was that not all those people live in Cleveland Heights necessarily. So you can't statistically, like they're driving through, but it would be a pretextual stop. But maybe we could talk a little bit more about, I want to get back to kind of put a pin in the fact that like Black individuals have different outcomes, but maybe we could talk a little bit about implicit bias as you see it play out.
Yeah, I mean, a really good book that I read that sort of confirms my own personal life experience in the legal system is by Jennifer Eberhardt. And she's someone who is actually from this area originally. She, I think, was born in Cleveland and grew up in Beechwood. Anyway, this is kind of the focus of her life's work. And she wrote a book called Bias, Uncovering the Hidden Prejudice. And she has studied police encounters and systems in the justice system. And one of the most interesting studies she did was reviewing traffic stops in Oakland and just listening to the words used by the officers when they stopped African American individuals and stopped white individuals. And what she found was that there was a respect deficit. That when you stop a white individual, the officer's more likely to apologize, to speak respectfully and kindly, less likely to immediately respond aggressively. And the reverse is true for Black individuals. And while these things are subtle, they color and inform and dictate to some extent the way the rest of the interaction goes. And when you repeat this over and over, it has significant effects on outcomes and how it plays out. And so implicit bias is this thing that, we all experience and have. It's not, and I think what makes this topic difficult is because people feel that they're being accused as being racist when we talk about bias and prejudice. But the reality is we all have these implicit biases. Sometimes they're just totally unconscious. But unless we confront them, we're never going to get past the way in which the justice system treats individuals differently. So these are the biases that inform our quick split-second decisions. And sometimes that's good because we need to make quick decisions in life, but other times we need to be conscious of the fact that we're making certain assumptions that are based on bias that probably are not legitimate.
And I guess we should probably talk about the statistics of what your office handles in the municipal and felony cases.
So
two charts here,
so our office represents anyone who is indigent, cannot afford an attorney, and is charged with a criminal offense. And in the felony context, when you look at the population of Cuyahoga County, for instance, it's roughly 2/3 white. But our clients, the people that we represent, the racial breakdown is roughly 2/3 Black. And so basically it's just kind of exactly split opposite from what you would expect just based on population. And in the municipal context, it's probably even a little bit more stark, although the city of Cleveland has a larger Black population. Our clients, it's closer to 50%. Our clients are almost 80% African American. And so, what we see is a system overrepresented by minorities.
And is that a twofold hit in that, like, minorities are being charged more, but then they're also qualified for the public defenders?
I think if you look at the breakdown, I mean, there are not a lot, especially in the felony context, there's not a lot of retained attorneys. So, it tends to be appointed. My guess is, I don't know this for sure, but if you looked at the entire universe of criminal cases, felony cases especially, I think you would still find it's far heavier African American than white, even if you factored in people who were able to hire their own attorneys.
All right, yeah. So then let's talk more about where to go. Police discretionary decision points, and then we'll get into the prosecution discretionary decision points.
Sure. So this is so going back to talking about implicit bias. So I think people think about the justice system as an objective system. Somebody commits a crime, they're arrested and prosecuted. But the reality is there is a lot of choices made by people involved in that system. And so, for instance, in the police context, the police make a decision about where to be, what community to police, which individuals to even approach and talk to, how to engage with those individuals, whether they pat them down, whether they handcuff them, whether they search them, whether they arrest them for a minor violation or give them a citation, and then what charges they would suggest to the prosecutor. So all these things there's no requirement that an officer do one thing. I mean, they're trained in certain ways, but they exercise choice, and as a result of that, a large amount of discretion, you can see significant disparities result from the exercise of that discretion.
And then that leads to the prosecution discretion. So I guess let's talk about that. And then I have a question about the relationship between the police and the prosecution.
Okay, well, one thing I did want to say, and just to put a couple numbers on it, and this is based again on Jennifer Eberhardt's study in Oakland. And I think it's just significant to think about this, that so she found that in Oakland, about 44% of the population is Black, but 60% of the police stops involved African Americans. And at every point, African Americans were treated differently. They were more likely to be handcuffed. 25% of encounters, they were handcuffed, whereas only 1 out of 15 white individuals were handcuffed. They were more likely to be searched, 1 in 5 stops versus 1 in 20 for whites. And what's interesting about that is the officers were no more likely to find contraband in the searches of Black individuals than white individuals. So that it's not like it was borne out in experience that it made sense to search. And African Americans were more likely to be arrested. So that's just 1 in 6 versus 1 in 14. So that just highlights, I think, factually some of the realities we were talking about. So then the next step in the criminal process is that the cases get passed over to the prosecuting attorneys who work with the police. And again, there's discretion here. The prosecutors aren't required to return any specific charges. They decide what charges to bring, and sometimes that means charging something as a misdemeanor instead of a felony. Another discretionary decision is whether to prosecute a child as a child or bind that person over to an adult court, whether to seek a high bond in the case such that the person can't get out prior to trial, or whether or not to not oppose a personal bond so they could get out. And then even things like whether to offer diversion, what sort of plea bargain to offer, what sentence to advocate for, all these are discretionary decisions that the prosecutor enjoys in deciding how to prosecute the law.
Yeah, and I guess one of the things that I didn't know until I started looking more into this is just how kind of day ruining this would be. Like, I could just be walking down the street, going to work, get stopped by the police, and for whatever reason, get arrested. And that enters into this whole, I guess what I'm getting at is the outcomes of some of this. So like, if I'm stopped and they determine that I need to be arrested for whatever reason, then this whole kind of machine kind of kicks in. And maybe you could just kind of give us a thumbnail of what that might look like.
Yeah, I mean, I think the thing is there's not much required to charge somebody with an offense. And so I think that's something that's important to remember. We're talking about probable cause, which is, it's not more than 50%. It's described as a fair probability that somebody may have committed a crime, which is, it's a very low standard, both to originally charge them and then to return an indictment. But the significance, once a charge is placed against an individual, the way that the machine operates is then it becomes very difficult to take that case out of the prosecutorial machinery, if you will. And I think one interesting example, just anecdote, that involved our office not too long ago with a good outcome, because we were able to get involved earlier. A person was arrested for allegedly trying to run over someone at a gas station during a dispute. And we were contacted in this case just by chance by a former client of ours who is a family member of that individual. And we were able to go out to the gas station to get footage that showed what actually happened during that interaction. And what the police did not see, because they arrived after the fact, was that the person that was allegedly almost hit had jumped up on the car, attacked, ripped off the windshield wiper off our client's car and started beating the car with the windshield wiper. And all our client did was drive away. But when the officer pulled up, their vantage point was different. But what was significant about this is because we were able to get the video footage right away, before a final charging decision was made, we presented it to the city prosecutor, and they ultimately didn't charge the individual. This would have been a different outcome if it followed its normal course, because at that point, if this person had already been indicted, yes, there's some evidence that's showing they didn't commit a crime, but now we're up against a view that, well, maybe they should take a plea to some sort of misdemeanor or something like that. And it creates a totally different power dynamic. And so most people don't have the opportunity to engage with a lawyer that early. And as a result, the process is a lot more difficult once there's a decision that's been made to charge you.
Right. I think one of the things that I learned too, which I think is a misconception in the public, is that there's I as a victim don't get to choose what crimes you're going to be charged with. That's police and prosecution. And then I'm out of it as a victim or as a.
Yeah, I mean, that is true. I mean, there is a statute, and then there was a constitutional amendment passed called Marcy's Law that provides for victim input. And so for that, the victim has the right to be heard. Prosecutor has to listen to them, but not follow what they say per se, but they have a right to be heard by the prosecutor and heard by the court. But ultimately, it's a decision of the prosecutor what charges to bring and whether to continue with those charges. I mean, we see a lot in the context of domestic violence, for instance, where somebody has called the police and their significant other's been arrested. A couple days later, they whether something happened or not, they've taken a different position. Now they're saying, I would like this to go away. I don't think this should be prosecuted. I was upset, whatever the case may be. But just because the victim who made the report doesn't want it to go forward, doesn't mean that the prosecution won't continue. And in fact, most cases it will.
Yeah, and I think that wanted to get to some of the plea bargains, because I think that one of the things that someone like me, who's pretty much middle class, never been arrested, never been in the system, I have no priors, I guess. I have no plea bargains, I have no convictions or anything like that. So taking your case, the example you just gave of the gas station, if it had been a different outcome and that person pled to something that they maybe necessarily didn't even do, the next time they are stopped, it's a different outcome completely, correct?
Yeah, I mean, it sort of has a cumulative effect, because as a result, once you have a conviction, you're probably viewed with a little less credibility and you're viewed a little more suspect. And sort of taking that example that I'd given before, and this is one of the tensions in the process, is that a plea outcome, if an individual has been arrested and they cannot make a bond and they're being held in pre-trial detention, they have a real incentive to try to resolve the case if they can and get out of prison or out of pre-trial detention, I mean. And so if a misdemeanor is offered, I mean, a lot of times people in a dark humor sort of way say, a misdemeanor is the same, basically saying that you're not guilty, And so if you're offered a misdemeanor in a felony case, often people will take it, because the risks of going to trial, risks of challenging, it means I may end up in prison, or if I take a misdemeanor, I will probably get probation or get out on some maybe even time served, and I can restart my life. And so, there's a lot of pressure that bears on this decision making, and it only increases with the severity of the charge. There's some charges that carry the possibility of life in prison or decades in prison. In those circumstances, even if the cases are weak, you may accept some sort of conviction just to avoid the possibility that you may spend the rest of your life in prison.
Yeah, and that's the sentencing is where we get into. So even if I plead to if I make a plea bargain, then I get sentenced. So it doesn't matter if I go to trial or not. And in the county, it looks like it's pretty. The statistics you have on the sentencing disparity are pretty dire, I guess. Pretty high.
Yeah, I mean, nationwide, the sentencing disparities are pretty crazy. When you look at it, white men who were born in 2001, so like were 20 years old, 1 in 17 of them will spend some time in prison. But 1 in 3 Black individuals, men born in 2001. And you think about it, it's 33% of every Black man is likely to spend time in prison. You see that locally too. In Ohio, the incarceration rate is almost 6 times higher for Black individuals than white. And again, in Cuyahoga County, you see about 66% of people sentenced to prison are Black, whereas the Black population is only about 30%. And there's a lot of factors that go into this. And again, I just want to emphasize that, people will say, well, does that mean that there are, the judges are racist or something like that? Again, there's just so many factors that go into how people get arrested, charged, et cetera. I don't think in most cases we're talking about any kind of like insidious, explicit racism, but some of it is just some of the cumulative effects of implicit bias that have built up over time that result in this. And I think one other big factor that plays into it is pretrial detention. So individuals in pretrial detention, you're presumed innocent when you're charged with a crime, and you have a right to post a bond and be out while you're, defending against the allegations. But some people, and depending on the charge, the bond, financial bond, is too high. So they spend all their pretrial time in custody. The result of that, and you see more minorities in that camp. The result of that is those are people that haven't been able to establish a job. So it seems like, well, what's the harm in sending them to prison? It's not like they have a job to lose. And they're more likely to plead. They're more likely to get longer sentences. You will see, not every time, but you're more likely to see a better outcome if your client is able to walk into the justice system dressed in street clothes, and you argue that they've been out for 6 months and they've been doing a great job, Your Honor. You could keep them out. They're not going to create a risk to the community. Whereas if my client's been detained for 6 months prior to sentencing and they're wearing orange, they already look like they should be in prison. And so it's just a totally different dynamic. And that's one of the reasons there's been pushes across the country to reform our bail system. And in some states, including New Jersey and Illinois, have totally gotten rid of cash bail. And there's some pending legislation in Ohio to do a similar, maybe not quite as aggressive, but similar reforms that could make a big impact on sentencing disparities.
Yeah, that's something, most people don't think about, that difference between like being in and being out. And even if someone has a job or it's a part-time job, then they lose it and they lose their house. I mean, if you're in prison for or jail, I guess, for 6 months, that's you're out of commission for a lot of things.
Well, I think what's interesting is actually there's been a number of studies done by the Pretrial Justice Institute that says that actually pretrial detention increases the likelihood that that individual will commit a future crime. Because as a result of being detained pre-trial, their lives are destabilized, they lose their employment, as you mentioned, they lose their housing. All of a sudden, they're in a totally different place than they were prior to being detained. So for individuals that are, and a lot of individuals who are charged with lower level offenses may get probation anyway, ultimately, even if they're convicted. But now, 5 or 6 months later, they don't have a job, they don't have a place to live, their lives are destabilized. It's a lot harder to kind of restart their lives. And so it puts them further behind the eight ball rather than somebody who was released pre-trial. So the consequences in terms of like, even if we're focused primarily on reducing crime, especially for low risk individuals, pre-trial detention is counterproductive.
Yeah, and in our discussion last month, we came across a statistic about young boys who have more interaction with the police are more likely to offend later in life. So in a year or two, they are more likely to create a crime or be caught for something, depending on how.
Well, I think that's really true. I mean, there are a lot of people that have studied the school to prison pipeline, as they call it, and how Black boys are treated differently from an early age, even in the classroom in terms of discipline. I recall my son actually got in a fight at school, and I was a lawyer. I went and met with the vice principal. I felt my son, made poor choices, but there was mitigation there. And I do think that he received a different outcome as a result of some of his, because of that, whereas I think, some individuals who don't have the resources and because of implicit bias and other things, had he been Black, would he have gotten the same outcome? Would he have been suspended from school, which he wasn't? I suspect he probably would have been. And I think the reality is that, then a person gets a label within the school, something else happens. Now they don't handle it internally. They call the police get involved. It's a minor thing in a way, but then they spend some time in the detention center. And it just continues like that. And then eventually you see that individual potentially as our adult felony client. So it's not like it has to happen that way or always does, but I do agree that the more kind of interactions that you have with law enforcement when you're younger will shape the likelihood that you're going to end up in adult prison.
Yeah, and then there's that intergenerational thing too. Like when you're taking the example, if my son had gotten into a fight, but I was in a pre-detention holdover and couldn't go, and then there's the whole thing about that as well. Yeah. I mean, and again, that's why I think a lot of these issues are not. There's not like a magic bullet that we could all say, well, let's just fix this thing and the system will treat everyone equally. There's a lot of little things that need to be improved, and that's really the challenge. And it ultimately comes down to the fact that the legal system is made up of people. It's not a machine where perfect decisions are made and where everybody can be treated the same. So it is a complicated system for sure. Yeah, and I was trying to find the article, but I think it was in Pacific Northwest. I want to say Portland, that the prosecutor just announced that they're not going to charge felonies for traffic stops anymore. So I think in my research, traffic stops seem to be like the majority of where police contact happens these days.
I think that's true. I mean, outside of like violent crimes where police are called out to a situation, traffic stops. And I think one of the things that people also talk about is in terms of reducing police shootings, both ways, of officers getting hurt or officers shooting or harming persons that they've stopped. And these are emotionally charged interactions that maybe aren't necessary. Like, do you really, and if you're thinking in a big picture way of how to reform the system, do you really need to pull somebody over because they're going 12 miles over the speed limit? Is there a better system for addressing minor traffic violations? And one of the things, and this was some years ago, but there was a very interesting law review article about noise in a motor vehicle and the number of citations or arrests that were issued to Black individuals. And actually this was back in 2001, but I'm not sure it's that different today. 88% it's in Shaker Heights. 88% of the citations for noise in a motor vehicle were to Black individuals. 81% Cleveland. And so I think the question is, are these police interactions really even necessary? I mean, I think we all agree that the police play a role in keeping our community safe, and I think that's important. But by having increased number of interactions with police and citizens in minor circumstances, I think it sometimes is a recipe for problems.
Yeah, and I think that that kind of buttress or goes nicely into the necessary steps that you recommend in your presentation.
So I mean, there's a lot of things that can be done to improve the justice system, and I think there's a lot of well-intentioned people working in that direction. One thing is improving, as we were just talking about, police interactions. I think removing pretextual stops as a legitimate basis would discourage excessive police citizen encounters that are not necessary, and would help reduce the racially disparate outcomes. I think that if we're going to have a justice system that treats low-income individuals the same as people with resources, we need to be able to get them attorneys quicker. As soon as they're being contacted by the police, they should be able to access an attorney. I think it's important to reform the bail system. We had talked about that a little bit earlier. It just makes such a big difference whether people are out or in terms of their outcomes. And ultimately, there is a statute in Ohio that allows the prosecutor's office to seek pretrial detention without bond for people who present a risk to the community and are charged with the serious offense. So much like the federal system, which basically there's very little cash bond in the federal system. Most people are out in pretrial unless the government demonstrates that this person presents a risk to the community. If they do present a risk to the community that's significant enough, whether they have a little money or a lot of money, it makes sense to keep them in pretrial detention. But if they don't, or if there's conditions that can, put them into the community, whether it be home detention or electronic monitoring, do it in a safe manner, then we shouldn't keep people locked up in county jail. And our numbers in the jail are increasing. I mean, we are facing challenges with respect to COVID and the jail population. But we were able, through concerted effort, to get the jail population was originally, and this is mostly pretrial detainees in our county jail, was originally over 2,000 people when the pandemic started. And then it got down to closer to about 1,000, but it's been creeping up ever since. And now it's close to 1,700 again. And so it makes sense to do what we can to reform the bail system. I would also note that there was a good op-ed in the Plain Dealer this weekend on policing, on changing policing. And I forget who wrote it, but it was good. In any case, what it talked about is changing the way we respond to crises and treating them more as, in many cases, as mental health or substance abuse issues, and having it and treating it less as a police encounter. And that's something that Cuyahoga County is, I think, slowly moving towards. And I think our county prosecutor supports it. I think the county council does. And they recently, and the county executive, they recently had a small sort of temporary diversion center set up, which the idea behind it is you arrest people or detain people, but instead of bringing them to the jail, if they're having a mental health crisis or substance abuse issue, even if there's an attendant crime that's not violent, most likely, you can bring them to this diversion center where they can get, they're just diverted, they're not even charged, they're diverted entirely from the system. And that's a huge, I mean, that's a huge shift in how we look at the justice system. And I know the county is looking at investing in a larger scale diversion center, which would be huge. And then the last two things on my list, and there's a million things obviously you could do, but is putting into place a more robust and effective post-conviction process that allows individual to challenge wrongful convictions. You don't have a right to an attorney in that context. Once you're convicted, you're on your own. I mean, and there are agencies out there will handle some post-conviction cases. There's the Ohio Innocence Project, but they're very difficult. There's a lot of procedural rules. Hearings, it's rare that judges will even give you hearings. So building that process up. And then also increasing transparency in sentencing. This is something that Justices Donnelly and Chief Justice O'Connor are sort of championing. It's a little controversial in the criminal justice system, but having some sort of sentencing database so we as a community and even the stakeholders in the system know what kind of sentences are being imposed, because that information is not easily publicly accessible on a bigger scale. So I know that's a lot of things thrown at you, but those are some ideas anyway.
Yeah, I think those are all interesting to think about. So I think that's pretty much what I had to cover. There was one thing, as you were talking about, was when you were talking about the diversion centers, I know that some, let me back up. We don't have a drug court in Cuyahoga County, correct? Not like Central.
No, we do.
Oh,
we do actually. And I will say that that's one thing that both in Cleveland Municipal Court and in Common Pleas Court, they've developed drug courts and mental health courts, and actually a couple other specialty courts like Veterans Court. And the drug courts have been really successful. I mean, I think it might be interesting for you to talk to one of the judges that runs it. Judge Mattia is kind of one of the primary judges. Sittenberg and McDonald also have them in Common Pleas Court, and Judge Moore in Cleveland Municipal Court. But they're very good programs. They're not always diversionary. So it's not always in the sense that if you succeed in the program, you won't end up with a conviction. But nonetheless, they're programs that are designed to address the root problem of the criminal conduct. And and I think we've all seen great benefits from those. And also the mental health court. We have multiple mental health court judges who, again, there's a crime at issue, so you can't it's not like you can just treat it only as a mental health problem, but at its root, that is the issue. And so rather than just treating it as a criminal problem, these judges and these courts tend to look at it more globally. And that has been a big success, I think.
That's great. I would love to see, just anecdotally, some sort of study done about how many people who commit crimes are actually under the influence of something, alcohol or drugs at the time, because it seems to be a high percentage of people are not.
Well, yes, that and individuals with suffering from mental health episodes or conditions. I mean, yeah, I suspect those studies, I don't have any right at hand, but I suspect some of those studies are out there in a national scale. I can just speak anecdotally that we have a lot of clients that are transferred onto the mental health docket because they have severe mental health issues. So it is a high proportion of individuals, that's for sure.